Good afternoon. So welcome to session 12, if I'm counting right, of our revision session. We are going to discuss aspect of contract, the doctrine of consideration. So we'll pray. In the name of the Father, Son, and the Holy Spirit. Amen. Heavenly Father, we thank you for the gift of knowledge and opportunity to prepare for this important journey. Grant us clarity of mind, diligence in study, and humility to learn. Bless our discussions today, that they may sharpen our understanding and guide us toward wisdom. Entrust our efforts into your hands, knowing that success comes from you alone. Amen. So yesterday we discussed a couple of questions in the area of remedies for breach of contract. Those who could not join us, I think I've shared the recording with you on the platform. So if you go to the Ghana Law and in the Ghana Law TV YouTube channel, you'll be able to access it. So this afternoon, we quickly want to revise consideration and discuss 4 questions. And then we are done with consideration, and hopefully we get a time and just clear privity and other topics quickly. Good. So consideration, as you have learned already, is said to be the quid pro quo element of contract formation. When we say quid pro quo, that is the element of exchange. But before that, let me remind you that when I used to teach my students contract in KNUSC and Pratt University many years ago and Lancaster University, I used to tell them that the proper way to understand consideration is to go back to the history of the common law in relation to contracts. So as we know, we have 2 main types of contract, okay? We have a simple contract on one hand, and then we have what we call the specialty contract. Specialty contract is also known as contract by deed or contract under seal. Now for specialty contracts, because it has certain formalities already, it must necessarily be in writing, it must have the seal of the parties. And for that reason, the law is that it is enforceable without the requirement of any other evidence as to whether somebody has actually indicated that you want to be bound by it or not. Because a seal is your official mark of authentication, okay? In the past, now this is because of technology and how the world have changed, seal is not as important as it used to be many, many years ago. Now, a seal was carefully kept under lock and key because if a seal was put on something, it was a mark of approval, a mark of giving a solemn assurance that you stand by whatever document is saying, which has your seal on it. And that is why if there was any breach, the court could enforce what the document was saying. So that is the reason for saying that a contract under seal, especially contract, does not require what we call consideration. Now, apart from that, we also have what they call the simple contract, also known as the parole contract, okay? Simple or parole contract. Now, for that, it may be by word of mouth, oral, or even if it is in writing, it does not require special formalities like the seal, or should not be a witness and so on. So it is still a simple contract or oral contract, parole contract. Now, for that, the law or the common law evolving had a challenge, and the challenge was that how do we distinguish between made up stories as whether somebody actually promised you or as a matter of fact that he actually promised you. So to draw the line, the courts needed to know, if you like, the motivation or the reason for you saying that someone had actually promised you, and the court should actually hold the person to it. So that requirement that, yes, what did you do or why did the person make the promise to you is what has developed and refined to be called consideration. And that is why we say that consideration is the quid pro quo, if you like, something in return for something, right? Element of exchange. Now, if you are saying that I promise to give you a bicycle and I've not delivered the bicycle, and the court should hold me to it, or the court should let me compensate you for not making good a promise, we must know what actually justifies that I made such a promise. Is it a case that you had made payment of money to me, or you had also promised to pay me money, or you've done something, or what? So that is the idea of consideration, okay? So therefore, when we talk about consideration, it applies mainly to simple contracts and not specialty contract, because specialty contract, by reason of the formalities, as I've indicated, the deed or the seal is not so much a problem. So considerations sit alongside other elements of offer acceptance, intention, and capacity, as you know. So consideration, the case of Dunlop against Selfridge, we come and discuss it again when we are discussing privity of contract. As you remember, that case is about a manufacturer made the tie, and then the tie was supposed to be sold to another, if you like, a middleman. And when they also resell it, they were supposed to make sure that the ties were not sold below a certain given price list in order to maintain a certain price for the commodity, what they call the price resale maintenance agreement. So when Dunlop sold to sold the ties through a dealer to Selfridge on condition not to sell below the price list. Selfridge cut the price and actually went against it. So Dunlop realized that some of the ties were in the market were being sold contrary to the price given. So they uh, sued Selfridge, and an issue arose as to whether Dunlop, not having actually sold the tie directly to Selfridge, okay? Because Selfridge got the tie from, I think, Dew and Co. If you look at the law report, Selfridge having obtained the tie from Dew and Co., there is no direct nexus, and that's the privity of contract. Come and talk about that later on between Dunlop and Selfridge. So uh, Dunlop uh, could Dunlop enforce the stipulation that Selfridge should, as a third party, should not sell below the price? And the court said, well, there's no contract between Dunlop and Selfridge, and for that matter, could not be enforced. But the court went ahead to restate the definition of consideration and stated that an act of forbearance or the promise thereof is a price for which the price of the other is bought. So just telling us that consideration is the element of exchange, as we have indicated. You also know the case of Thomas and Thomas. Thomas and Thomas, somebody made a will in which that the property should be given to the widow. The executors of the will actually conveyed or promised to convey the house to the widow in consideration of the husband's wishes, okay? And that she agreed to pay £1 per year and keep the house in repair. So there was a problem along the line, and then the matter came to court. And as to whether the consideration which had been provided was a valid consideration, the court took the view that the statement by the executors that in consideration of the husband's wishes was not a good consideration, was not a valid consideration, because they are just a mere, if you like, motive or emotions. But most importantly, the £1 which the woman had agreed to pay as an annual, if you like, the ground rent was enough consideration, despite the fact that £1 is nothing, but it was something of value in the eyes of the law. And Thomas reminds us that consideration need not be adequate. must be something of value in the eye of the law. Yeah, you know these things. So we are just rushing through as uh, a reminder or revision. And if you look at the other, case law, we get the point that uh, where you have conferred the benefits on a promisor, or where we've had like a forbearance, or detriment, okay, to you as a promisee for the benefit of the promisor, that will also be like the consideration. Various types of consideration, as you know, executory consideration, that is where both parties have actually made a promise, so mutual promise. I promise to give you a laptop. Then you also said I promise to pay you 1,000 Ghana cedis. Okay, so we have promises, and our promises are yet to be carried out in future. That is why it's executory. So yet to be carried out, but particularly I say on the credit. And we also have executed consideration uh, where, especially the unilateral contract, like a Carly and Kabali smoke ball, okay? Anyone who will buy the product smoke ball and use it according to the designated usage and get the influenza will be given a compensation of £100. So it just like somebody said, anybody who will find my missing dog, Cindy, my dog sadly died about a month ago when I was away from my house. Very sad. A tiny dog was called Cindy. So if you will find my missing dog, Cindy, I'll give you 100 Ghana cedis. So here, I have promised, that's a one-sided, unilateral, okay, in exchange for an act. So um, the consideration will be you doing the required act. If you find Cindy, the dog, and bring it, uh, you have provided consideration. Again, uh, past consideration is only stated as a type of consideration, but as a general rule, past consideration, which refers to an act done before the promise is made, is not considered a good consideration. The reason being that uh, there must be a promise before consideration and not a consideration before a promise. Simply put, somebody must have made a promise and then respond to that, the consideration, and not the other way around. So past consideration is the reverse. So if you look at the, let's say, Rescola and Thomas, somebody sold the horse, and when the horse was about to be taken away, the other party told the buyer that, oh, I tell you, you've not wasted your money at all. This is a good horse. Later on, it turned out that the horse was terrible, not a good horse. So he sued to enforce the statement that the horse was good. And the court said that, okay, what consideration have you provided uh, to enforce the promise by the seller that the horse he was selling to you was a good horse? And he said that the price are paid for the horse. But the court said that if you look at the sequence, you had made the payment before the statement was made, before that promise that the horse was good was made. And for that matter, your act of consideration is a past consideration and doesn't support the later promise. It was not good. The same thing apply in the case of Ray McArdle, as you remember. The wife of a beneficiary, the will made improvements to the family bungalow. Later on, other beneficiaries signed to pay her the money that she has expended, about £488 in consideration of the works that he had already done. And the court said that uh, because she had already done the work, okay, before the promise to pay the money was made, uh, that will be past consideration. So the promise was not enforceable. So, but this is a general rule. We have other exceptions, that is circumstances in which a past consideration will be treated as a good consideration, as happened in the case of a Lampley and Brightwit. A very interesting case, very old case from the 17th century. Someone had committed murder, and there was a particular person who was supposed to have the ear of the king, okay? And that person was actually entreated to go and plead with the king for royal pardon, something like what you call the prerogative of mercy, okay? Just like maybe in Ghana, somebody said, okay, maybe the chief of staff or maybe the president brother, okay, let's say Mr. Ibrahim, is supposed to have the ear of, let's say, His Excellency the President, John Dramani Mahama. So please, can you use your good relation with the president to convince him to grant me presidential pardon so that I don't have to bear the punishment for having been convicted for murder. That was a similar situation in Nample and Blightwit. So the person did it, and after obtaining the pardon, okay, when he had been set free, he promised to pay, let's say, £100 as an appreciation, okay, for what he had done in trying to get the king to grant the royal pardon. But somewhere along the line, I mean, typical of so many human beings, when they're in trouble, they are very nice people. When the trouble is over, they become different. So this man too behaved like a typical human being. He didn't want to make good his promise to pay the £100, and he was sued. So when he was sued, the issue arose as to whether consideration had been provided for the promise to pay the £100. And the consideration was supposed to be the fact that the man traveled from his village to where the king could be assessed several times and then got the king to grant the pardon. Now, the court said that this situation was distinguishable from those cases in which we say that a past consideration is a bad consideration. The reason being that the court said that there was a prior request, okay? So here, he had requested him to go and plead with the king. And it was reasonable under the circumstances that something could come out of it later. So subsequent to the prior request, having now promised to show appreciation by paying £100, the prior request which had been made and delivered on could be relied upon as a good consideration, as an exception to the rule that a past consideration is not a good consideration. So the takeaway is that where what is being relied on as a past consideration can, for example, be seen as having been requested by the promisor, then that could be a good consideration. Similar thing in the case of Ray Cassie patent Stewart against Cassie. We also have a statutory exception. What are some of the statutory exceptions? Well, if we look at the Limitations Act, we use to call Limitations Decree. There's this principle, what they call the acknowledgement, okay, revival of time-barred debts. If you look at the law, for example, we talk about the fact, when we discuss remedies, we talk about the fact that simple contracts after 6 years, it become a statute word bad. Okay, so where you are supposed to recover debt for me and you waited more than 6 years, technically, your right is unenforceable. Okay, but there's a way by which you can revive it. So let's suppose that you write to me a demand notice that I should come and pay, despite the fact that the 6 years have elapsed, and I reply, and probably I plead for a bit more time. Now, that letter or that act on my part will be deemed as a sign, if you like, a written acknowledgement. okay, which revives the right of action, despite the fact that the original 6 years have elapsed. And that can be relied upon as, if you like, as a good consideration. So therefore, if after the 6 years, having signed the acknowledgement of the debt, you don't honor it and you are sued, you cannot plead the fact that uh, the debt that you owe, which the person is relying on as a consideration, is a past consideration because you have signed the written acknowledgement of it, and that has revived the right of action from the date of the acknowledgement. So you played the time by if 6 years have run, but if the creditor has a written or signed acknowledgement or part payment, then the time will start from that moment and not the 6 years. So that is how it is. We also have a bill of exchange. If you look at the Bill of Exchange Act, uh, which the law which regulates a bill of exchange, checks, promissory notes, and so on, a check or bill of exchange, uh, somebody having written or something that you pay a certain amount of money. Like, let me use check as an example. Check, for example, I write a check of 10,000 cedis for you against my bank, let's say GCB. Now, if the check, for example, is dishonored, okay, you can sue me for breach of promise to pay the 10,000 cedis, which is the face of the check. And then question may arise as what consideration have you provided? So the consideration you are provided will probably be the fact that you sold some books to me, or you provided some services to me. And that is why I wrote the check subsequently. Now, going by orthodox analysis, as we have seen, one will say that the thing you sold or the services that you rendered actually predated the writing of the check. Okay. So the check become like the promise I made to pay. So the promise is after the act. So that typically is like a past consideration, as along the lines of what we have seen in the other cases like the Rescola and Thomas and so on. However, the Bill of Exchange, for example, Section 25 will tell us that uh, where you have antecedent debt or liability, like the one I explained, you having sold goods or you having performed a service, that is antecedent debt or liability. That is a valuable consideration. So here, it is the law which is saying that uh, a past debt is a good consideration. So if you are not being for this statutory provision, one will argue that the antecedent debt or liability is not a good consideration, but the statute say that it is. So let us keep that in mind. So when it comes to negotiable instruments like the bill of exchange, promissory note, checks, and so on, the statute expressly validates antecedent debts or past debts. So let's keep that in mind. Another thing worth remembering is the principle that consideration must move from the promisee to the promissor. In other words, the person seeking to enforce the parole contract should be the one that ordinarily provided the consideration. So you know the case of Twaddle and Atkinson, the two fathers of a young couple or a boy and a girl about to get married, and each of the fathers promised them that they'll be contributing a certain amount of money to support them. Now, of course, the father-in-law, that is the girl's father, could actually not come to terms with the fact that I'm giving my daughter to you and you still want me to be sponsoring. Then so probably he had a change of mind and was not actually paying. And so when uh, the son-in-law sued the executors of the father-in-law because the father-in-law died, when he sued them for the outstanding arrears from the promise that the father-in-law had made to support, an issue rose as to whether the contract between the two fathers-in-law, okay? This son-in-law, had he provided in consideration? In any case, he was a stranger. So the court held that the son-in-law could not enforce the promise against the executors of the father-in-law because he had not provided any consideration, quite apart from the fact that there was no proof of contract. So the takeaway from Todell and Atkinson, as you know already, is that only the one who furnishes consideration can sue on the promise. So that is the classical position of the law. But as you notice, under our Contract Act, Act 25, there has been some modifications of that. And it is permissible for a third party to provide consideration and it will still suffice. And even consideration itself, as you will notice, has largely been uh, modified under Act 25. We also talk about adequacy and sufficiency of consideration, and we often make the point that consideration must be sufficient but need not be adequate. Okay, and when we say that, what it simply means is that consideration must be something of value in the eyes of the law. The courts are not interested in trying to compare whether what the two parties are giving in a bargain, in exchange, whether they fairly correspond to each other. That's not the business of the court. All that the court is interested in is that somebody is giving something which can be quantified in money terms, right? So that we know that that is what you have provided. So you take the case of yeah, somebody is making annotation. Do you want to say something or you're just playing with my screen? Who is that? Any question? Okay. The person who made the annotation, do you want to ask a question? Go ahead and ask. Okay. Yeah, so we know, no Chapel and Nestle, where the court said that even wrappers of a chocolate could be like a good consideration. And we often say that when it comes to conveyance, like peppercorn, right? Peppercorn is supposed to be something very insignificant, and yet the court recognized it as a good consideration. And that was why, in the case of White and Bluet, the court said that no, somebody promising to release another from a debt to stop complaining to the father was not a good consideration because it's not something really of value in the eyes of the law. And as we have noted, consideration must be something of value in the eyes of the law. So vague forbearance, for example, just like we saw in the White and Bluet, will not actually suffice as it were. So what are the instances in which the law will say that consideration is insufficient? We are looking at the common law, and then we'll talk about the changes made by our law, okay? So at common law, when you perform a public duty, it is not a good or sufficient consideration, as happened in Collins and Godfrey. Somebody had been subpoenaed, okay? That is officially summoned to come and testify in court proceedings. But the person who caused this person to be subpoenaed was not sure whether the witness will really come. So he went out of his way to promise him money if he will come. So he came, and later on, he did not pay the money he had promised, and he sued him. And when he sued him, a question arose as to whether he had provided consideration for the promise he made to pay him for attending. And the court said that in any case, if you have been subpoenaed to attend court proceedings, that is a legal obligation because subpoena a testificandum or subpoena tecum, if you don't respond to it, you become amenable to contempt of court proceedings and you go to jail. So you have no choice in the matter. So the court said that you coming cannot be used as a consideration because you are just carrying out your public or statutory duty. But in Glassbrook Brothers against Morgan County Council, as you remember, the court said that where you have done something extra, okay, or something no more than what the law required, that would be a good consideration. As we notice, there was a mine company, there was a threat of industrial action, and the management was afraid that maybe their installation may be destroyed. So they arranged to get the police to come and station some of their personnel on the premises. And the police said that was not necessary because we have an arrangement. If there's any incident, we can just rush onto the scene. But they insisted that no, we want you to be on our premises. And they were actually given even like a bail. And later on, when they decided not to pay and they came to court, they wanted to put up the argument that the police, coming there, they were doing their statutory duty of law enforcement. But the court said that no, they had gone beyond their strict duty because it's not their strict duty to deploy personnel on private premises, including commercial companies' premises, as it were. So let us keep that in mind. Of course, you also remember the changes which have been made by our own law. If you look at, for example, Section 9 of our Contract Act 25, that the performance of an act or the promise to perform an act may be sufficient consideration for another promise, notwithstanding that the performance of that act may already be enjoyed by some legal duty, whether enforceable by the other party or not. So you notice that at common law, like cases like Stilk and Marrick, which you remember, the ship, where some of the workers actually deserted, and then the captain or master of the ship promised to pay the remaining seamen extra wages, and later on he decided not to pay the sue, and a question arose as to whether he had provided consideration. And he said that under their contract of employment, they already enjoy to work hard for the ship to complete its voyage or journey, so they have not done anything extra. So that was Silk and Marrick. Of course, in Hadley and Ponsonby, has to remember similar set of facts. The court said that because maybe the number of desertion was so huge, when the master of the ship promised to pay them extra, it should be understood as innovation. That is a new contract having come into being, and that was enforceable. But if you come to our own jurisdiction, Ghana, as we have quoted from Section 9 of Act 25, it says that where you promise to perform an act or you perform an act, okay, which is required to be done by law, or like us in statutory public duty, like in the situation in the Collins and Godfrey type of cases, or enjoyed by law in terms of maybe an existing promise, such as we have in the Silk and Marrick situation, it is still a good consideration. It is a good consideration. So our law has relaxed the common law rule regarding performing existing duty or public duty. So that is the takeaway. Okay. But despite the fact that performance of existing duty or duty imposed by law is a good consideration, public policy consideration may also defeat it. For example, if you look at the case of Kessie and Charmant, you remember the ambassador whose services have been solicited to enable a Ghanaian company operating in Liberia to obtain a timber concession and some other things. He did that, and later on, when he came back on retirement, he saw as ambassador, he sought to enforce those promises, and question arose as to whether those promises were enforceable. The court said that yes, in terms of consideration, yes, he had provided consideration. It did not matter that what he did could be considered as even like a statutory duty. But more importantly, the contract could not be enforced because it was contrary to what public policy, as you know. So that was the situation in Kisi and Charmant because he was using his office for a private or benefit. So that was the crux of the matter. And similar points happen in Shandorf and Zeni, Ampofu and Ferrini. So we've discussed Stilk and Marek, so we'll not go back to it, except to say that at common law, one exception to the Stilk and Marek situation was where a person has an existing contractual duty, okay, and he either threatened not to carry it out, and the other party who was supposed to benefit from it promised extra payment so that he will continue to do it and not breach the original contractual duty. Williams and Ruffy Brothers tells us that that could be a good consideration because as you notice, in William and Ruffy Brothers, the main contractor had promised extra payment to the sub contractor because if the subcontractor had actually not met the deadline, it was going to let the main contractor default in meeting the agreed timeline, and that would have attracted some liquidated damages for delays, as it were. So they promised the subcontractor extra, and the subcontractor actually delivered. And later on, the main contractor didn't want to pay. And question arose as to whether the subcontractor had provided consideration. And they said that the consideration was that uh, by actually finishing, they had enabled the main contractor to avoid breaching the original contract. So they had some benefits. And for that matter, there's a practical benefit, and they had avoided penalty under the original contract. And that was a good consideration. In any case, in view of the court, there was no duress. The subcontractor or the main contractor had not actually been subjected to duress, unlike the situation you see in the case of DNC builders against a race. That one is a different type of case. Yeah, so at common law, we've also talked about the fact that duty owed to a third party, as a general rule, cannot be a good consideration. But under our law, as you notice that a third party can actually provide the consideration. Now let's talk about part payment rule. The rule in the Pinel's case, and as confirmed in Fosambia. So the general rule is that where you make a part payment on the due date, that cannot be a satisfaction of the whole debt. It's not a good consideration unless fresh consideration had been made. In other words, you owe somebody 10,000, okay? You're supposed to pay it on the 16th September. Then the person said that, okay, if you can pay 5,000 cedis by 2nd September, I will write off the whole debt so that you don't owe me again. Now, that is good. But if, for example, it had been that on the 16th September, pay me 5,000 and then I'll write off the whole debt, then Pinel case is saying that that is not a good consideration. So if you make part payment on the due date, let's say the 16th September, then that is not a good consideration. The only exception is that where there has been fresh consideration, maybe earlier payment. For example, if instead of the 16th September, you are paid 2nd September, then if I promise that, okay, pay on 2nd September, then I write off the rest of the debt so that on 16th September, you are not obligated to pay anything. That one is a different matter, okay? So the part payment rule says that where you make a part payment of the debt on the due day, as a general rule, that is not a good consideration to support the promise to forego or to waive the rest of the debt, the remaining debt. Like force and beer, the same thing, and principle. No, somebody had a judgment debt, and the judgment creditor decided to allow the judgment debtor to pay by certain installment, and that she will not claim interest, which ordinarily should accrue on the judgment debt. So the judgment debtor, Dr. Fox, having actually paid, no, the judgment debtor having actually paid according to the agreed installment. Prof, me try the online, I call you, right? Having actually paid the judgment debt according to the agreed installment, later on, the judgment creditor decided to pursue the accrued interest on the judgment debt. And Dr. Fox put up the argument that you cannot do that because we had an agreement that I should pay the judgment debt according to the agreed installment. Now, the court held that Ms. Beer was entitled to claim the interest because Dr. Fox had not provided any consideration by Ms. Beer that she waived the interest accruing on the judgment debt. But if you look at Section A2 of our Contract Act, you notice that it has abolished the common law rule of part payment. So Section A2 is to the effect that a promise waive the payment of a debt or part of a debt or performance of some other contractual or legal obligation shall not be invalid as a contract by reason only of the absence of any consideration therefore. So that effectively says that the creditor's promise to waive is binding, and there's no requirement for consideration under our law. So let's keep that in mind. And then let's jump to promissory estoppel. Promissory estoppel, I mean, that is an interesting area for contract teachers or examiners. So when you learn consideration, you must also know promissory estoppel. So promissory estoppel, in a sense, is a way of circumventing the part payment rule in the penals case and in the first beer. And it had already been articulated in the old case of Hughes against Metropolitan Railway, okay? That principle had already been articulated there, but it was made popular by Lord Denning later on in the High Trees case. So it's not the case that Lord Denning actually developed the promissory estoppel, it's already there. So simply to the effect that if one party leads the other to believe straight rights will not be enforced and the other acts on it, equity may prevent insistence on straight right without notice opportunity to revert. In other words, if you have a right against someone under a contract or some transactions, and you create an impression for the person to believe that you are not going to insist, you are not going to really go by your right to have against him or her, and you make he or she to believe what you are saying, and he or she will organize his life or his affairs on basis of the impression you have created that you are not going to insist on your straight legal rights. And later on, you will not be permitted by equity, right, on basis of a good conscience, to turn around and say that uh, you now want to rely on your straight legal right. So that's a huge against the Metropolitan Railway. And uh, central landing property, as you notice, that during the World War, properties have been led to a company which provides accommodation blocks in central London. And because of the bombing here and there, people had actually abandoned central London for safety. And the company which was running the business, that is the high trace, running like the business of providing accommodation, we're not getting tenants. And the company which actually owns the properties, okay, which actually owns the properties, they felt bad for them and decided to make life easier and said that, okay, for the so long as the war conditions continue and things are not normal, we are not going to let you pay the full rent. We are going to slash half of the rent off. So we just pay half for so long as the war continues or the war conditions subsist. So that was the state of affairs. Now, after the war condition had actually come to an end, there had been a bit of arrears in payment of the rent. So, at some point, having exchanged letters, they reached an agreement that let us go to court and then let us find out whether the court will agree if the half of the rent, which had been not demanded or suspended during the period of the war, could also be recovered from us. So it was a bit like a friendly litigation. So when they went to court, the court took the view that once there had been a clear promise intended to be acted on, a clear promise here was that so long as the war conditions subsisted, don't pay the full rent, and had actually been acted on in the sense that the company had actually organized their business affairs on basis of that promise. Then such a promise was binding, and if it was not actually binding, it will work injustice, and equity will not countenance that. So, promissory estoppel is simply to the fact that where a representation has been made that the promissor or the representor will not insist on his straight legal rights against the representee or the promissee, and then the representee or the promissee actually relies on the representation so made. Then, subsequently, the representor or the promissor will be precluded, will be prevented, will be stopped from going back on his word to try and insist on his straight legal rights. So that is how it is. So reliance, as will later on be articulated in Allen against the El Nasser, is required, but not necessarily detrimental. Initially, the impression was created that you must rely on the impression created to your detriment, to your disadvantage. But subsequently, the jurisprudence clarified that all that is important is that you rely on the promise that the straight legal right will not be acted upon. But it need not necessarily to have been to your detriment or disadvantage. So it suffices that the promisee conducted affairs on the faith of the promise. So, I mean, similar point I made in Combe and Combe. And Combe and Combe remind us that promissory estoppel is a defense, okay? And that is why I highlight the famous aphorism. It is a shield and not a sword. So promissory estoppel is a defense. It's not the cause of action. In other words, the promisee cannot go to court and ask the court to enforce the promise to vary, or not to insist on the strict legal rights against the promisor. No. On the other hand, the promisee will have to wait. If the promisor decides to take an action against the promisee for having defaulted, then the promisee will face that with the defense and say that, but you made the representation that you're not going to insist on the strict legal right, and I base myself upon that. So you are a stop. So that is how it works. So it is a shield, it's not a sword. Again, two metal against tungsten, and then Ajayi and Briscoe also suggest that promissory estoppel does not extinguish the right, but it's only suspensory. That is to say that the promisor may revert to the strict rights on reasonable notice, giving the promisee a chance to resume possession. In other words, just like if you take like the central line case, they said that for the period of the war we suspended, we are not going to demand the full rent. Meaning that if the promisor wants to resume the original scope of rights against the promisee, he must give notice to the promisee that the promisee will know that we've gone back to the original terms and no longer the varied terms, as it were. But of course, where you have acted unjustly, as in the DNC builders against race, where economic pressure was brought, then estoppel will not actually act. As you remember, some workers had actually done the work, and the wife of the man they did the work for went to them and said that unless they accepted the lower payment, you're not going to get anything. And because they were hard pressed, they accepted the payment. And later on, they sought to demand the rest. And the question was whether their initial implied statement that they were accepting the lower payment offered by the wife to actually end everything, whether that was binding. And then the court said that there was some inequities over there because they have been subjected to economic pressure, and that was not binding. Now, let us also note that under our law, if we look at section A2, section 8, subsection 2 of Act 25, first, a promise to waive the payment of a debt or part of a debt or the performance of some other contractual or legal obligation shall not be invalid as a contract by reason of the absence of any consideration therefore. So therefore, our section A2 with respect to waiver promises, like waiver promises or even like the variation of contractual rights, I think it provides a firmer protection against the estoppel as we have in the high trees case, because here it is the law which is saying that a promise to waive is binding. So you don't need to show that the other party actually rely upon the promise or not, as the requirements for promissory estoppel will let us know under high trees case, and then Ajayi, El Nessa, Kum Ben Kum, Two Meta, and those type of cases. So let's keep that in mind. But if you look at section 26 of the Evidence Act, we also have this estoppel by own statement or conduct. So an argument to be made that quite apart from the common law, we have also given some legislative footing. So section 26 of the Evidence Act says that except as otherwise provided by law, including a rule of equity, when a party has, by its own statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. So, in a sense, Section 26 has provided a statutory foundation for estoppel in our law. And as we have just quoted, that a party may be precluded from denying the truth of a state of affairs, which by words or conducts they intentionally cause or permitted another to believe and act upon. So before I move on to look at the questions, I would like to pause here if you have any clarification to seek. Otherwise, we have some few questions to discuss. Okay, I don't see uh, any, and so let's look at our question. So please look at this question. There is also a past question I think I have used some years ago when teaching some students. Yeah, so look at the question and try and put down some points before I come to discuss with you, okay? And I'd like to take one or two responses from you.
going to culminating in the establishment of our committee under Article 146 clause 4. The nation was further duly informed when we commenced our work on the 15th of May 2025.
Okay, we have some time now. Can we get some responses? Yeah, will anybody share his or her thought with us with respect to what is required in this question? On 1st December, Colin agrees to construct a swimming pool for Dave at the price of 3,000 Ghana cedis. Completion by and payment on 1st June. Colin subsequently purchases tile from Eric. The price of 500 Ghana cedis will be on 1st April. Colin has miscalculated the cost of construction and by March is in considerable financial difficulties. He explained his pride to Dave, who gradually agrees to increase the price of the pool to 3,400 Ghana cedis, of which 400 is to be paid on 1st April. At the same time, Colin says to Eric, you will have to accept just 400 Ghana cedis on 1st April. I won't be able to pay you anymore. Colin, having received the money from Dave, pays Eric the 400 Ghana cedis, which he then reluctantly accepts as full settlement for the tiles. By 1st June, the pool has been completed, but Dave pays Colin 2,600 cedis. Eric now claims an additional 100 Ghana cedis from Colin. Advise Colin. Anybody?
Yes.
Yes, please go ahead.
So I think it deals with consideration and one of the reforms the Contract Act 1960 has made to the common law position of constitution in Ghana, especially with acceptance of part payment of a debt. So I strongly feel that he agreeing to accept part payment of the debt now, he cannot come back to sue or come and claim for the rest of his debt. That's my humble opinion, sir.
Okay. Right, thank you. Any other?
Doc,
Yes.
yes, like my brother just said, we are looking at consideration. Key principles that we are going to look at it is the common law position on part payment of a promise to forgo one's legal obligations as in the common law and compared to that of Ghana's position. And we are also looking at I think promissory estoppel. Then we are also looking at another aspect of adequacy of consideration. So these are things I've also gathered. We are looking at whether or not the claim of the extra 100 is valid. These are the things we are going to look at.
Right. Thank you very much. I want to hear a lady's voice now before I move on. I'm a father of 3 daughters, so I always want ladies to be active too, please. And ladies, okay, since you are not talking now, I'll talk to myself. Good. So the issues which, of course, in terms of the area of the law, I think the contributors are right. So issues we will be looking at include whether Dave is bound by his promise to increase the pool price from 3,000 to 3,400. So the original was 3,000, but later on he made a promise to pay more. And then whether Eric is bound by his acceptance of the 400 cedis in full settlement of the 500 cedis debt, and whether Colin can recover the balance from thereafter underpayment. Now, my dear students, please, I want you to pay attention to how the issues are actually, catch or framed. You see that an effort is made to try and use the relevant facts together with the principle of law working at the background of our mind, you see, to form or to formulate the issue. So that when we read the issue as you have made it, clearly it signals us that you know the right path, So as we have indicated, you have to take the issue one after the other. So whether Dave is bound by the promise to increase the pool price from 3,000 to 4,000. So that is the issue one. And then you discuss. And so in discussing it, you tell us the law. As I said, this is just for teaching, but you don't need to be writing like rule. Just go ahead and state in topic sentence. And this is just an outline. We don't expect you in exam just to do this. This will not be right. We want you to write the principles in proposition form, right? In a proposition form or topic sentence, okay? But just an outline, we notice that if you are going by even like the common law, Stoke and Marek will tell us that carrying out existing contractual duty is not sufficient consideration. And then the exception is Williams and Rufford Brothers, that where a practical benefit has been conferred on the promisor, then that could actually be a good consideration. But that is really not important, as our friend has actually pointed out that if you perform a promise which is already required or enjoined, it is valid even if it is a legal duty, and that will suffice as a consideration. So if you look at what we have here, one would say that Dave gained a practical benefit because of the completion of the pool, despite Colin's financial troubles. And for that matter, Colin's continued performance is a sufficient consideration, and Dave is bound to pay the promised 3,400. But if you take, as I said, if we take our law, the issues of even Stoke and Marek and then the Williams and Rufford brother is not really a big deal, because our statutory provision says that where you are enjoined by a legal duty, be it another existing contractual promise, a public duty, it is still a good consideration. So that one is binding. And again, we have another issue with respect to that's what the other person started with, I think the part payment issue. Whether Eric is bound by acceptance of the 400 Ghana cedis in full settlement of the 500 cedis debt. And again, you have to tell us what the law is. And as I told you, you have to be formal. Don't do it like how we have done it in this teaching outline, okay? This is just for teaching outline. But in your answer, you must write the principles in full sentences, proposition form, right? Or topic sentence form, together with the corresponding authorities. But the substance of the relevant law here will be, yes, of course, you notice the Pinel's, the rule in the Pinel's case, that part payment is no satisfaction unless first consideration at common law will have been applicable. But again, unless somebody can answer this without going through the route of the Pinel, and then just start right from section 8, subsection 2, because that is the law. Section 8, subsection 2 says that a promise to waive is binding. Whether or not there is no consideration, it is still binding. So that settles it. But then if you want to display that you understand the law beyond the average, then you have started by saying that yes, at common law, as reflected in penal case and force and beer, part payment it cannot be a satisfaction for the whole debt unless rest on duration is provided. However, under Ghanaian law, per section 8, subsection 2 of the Contract Act 1925, a promise to waive a debt is binding, even where there is no consideration. And you have actually made your point. Then you go ahead and then you do the application and the analysis. So here you see that Eric accepted the foreign receipts as full payment. If you go to the story, like if you go to the facts, and we see it over there, we see it that you have to accept just foreign receipts from first April. I won't be able to pay you. They are told that pays Eric, which Eric receive, he pays Eric for $100, which he then reluctantly accepts as full payment for the tithes, isn't it? Good. So Eric accepted the $400 as full payment. If we argue, of course, over here we can disagree. When it comes to the application and the analysis, we can disagree, but we cannot disagree on the law. We must all state the law correctly. But in applying the facts to the law and the analysis we are making, there can be disagreement. That is why, even in court, we can have a group of judges who disagree as to how the law should apply to a particular set of facts, or lawyers disagree. That is quite legitimate, but we cannot disagree on what the true position of the law is. So here, it may be argued that no serious coercion was actually shown, in which case DNC builders against we probably could have come in. But mere financial difficulty is not the worst. So under Section A2, Eric cannot later demand the balance as it was. So the promise is actually binding. So Eric is bound, and Collins does not owe the 100 Ghana cedis. So that is how, if you like, you go about it. And the other one is about the Davis under payment. And failure to pay full agreed price, of course, the breach of contract. And that one, you apply what we'll be discussing in the previous lessons. So Dave owed 3,400, but he paid 2,600. And for that matter, Collins is entitled to the balance, which is the 800 Ghana cedis, so he may sue. So as I say, you must always have your overall conclusion. So Collins can enforce David's promise and recover the 800. Eric cannot claim an additional 100 Ghana cedis because waiver is binding under Section 8, Section 2 of Act 25. Let's take this question. It's an essay question, and the question was this: what is, this is also a past question I've done before. What is or what are the purposes of the doctrine of consideration? Is the doctrine of consideration and its related equitable doctrine of promissory estoppel still necessary in the light of Act 25? Well, there has been some debate, okay, that strictly speaking, if you look at Ghanaian situation, since 1960, one could argue that the way we should even discuss consideration in contract should be completely different. But then if you look at the case law and the test writers' commentaries, we still behave as if Act 25 has not done much. So that is the purpose of this question. In view of the modification of the doctrine of consideration by Act 25, is consideration still necessary? So that is the question. Of course, Professor Donna Hammond has an old article which is still very useful. I think the modification of the consideration doctrine at common law. If you haven't read it, I think please read it. You can just get it from University of Ghana Law Journal, and I think it's on the Law Finder, if I am not mistaken. So as we have already indicated in the introduction, consideration for simple contract, okay? We can always even start from the two types of contract, specialty contract and simple contract. Specialty contract has formalities including sales, so there's no requirement for consideration. A simple contract may be in oral form or may be in writing without the need of a seal. And for that matter, there may be difficulty as to its genuineness. So therefore, consideration, which is the element of action, comes in to serve evidentiary function. It shows seriousness of the promise. And that is why even Thomas and Thomas will say that £1 will even suffice. And again, consideration is the quid pro quo, the element of action. So if you are using the bargain and theory, that is somebody is giving something in return for something. There's that kind of reciprocity, okay? And it distinguishes, promises from gifts. So it distinguishes the enforceable promises from bare promises, what we call the nudum pactum, or there's a gratuitous, if you like, the promises or gifts. The contract is not about gratuitous promises. It's not about naked promises or nudum pactum. It's about enforceable promises, and consideration enables us to do that. So consideration serves as a filter, drawing the line between ordinary, if you like, ordinary, social promises and so on, from a serious enforceable promises, as it were. But so still, part of the first aspect of the question, there have been some criticism of also what the consideration is, that is too technical and formalistic. As you can notice, if you look like the old cases, especially when it comes to adequacy and sufficiency, the cases like the Starlick and Stilk and Marrick, Adley and Ponsonby, William and Ruffield brothers, and then the case of Collins and Godfrey, Glamorgan and County Council, Sheffield, UAC against Harris. If you look at all those cases, you notice that there are some unnecessary technicality and formality as far as the consideration as the doctrine is concerned. And sometimes it can also frustrate a genuine agreement, like we saw in the Macadil. And because of the unnecessary injustice and technicalities associated with it, there was a equity actually had to circumvent the common law, as we have, for example, seen in the promissory estoppel, how equity will come in and prevent reliance on straight rights, where a promise induces a reliance. So someone has a straight contractual right against another person, creates the impression that I'm not going to insist on it. The other person relies on it, and later on, the person goes back on it. Equity, which operates on conscience, or that was not good enough, that was unjust. So promissory estoppel was developed, and promissory estoppel, as we have seen, is a shield, it's not a sword. There should be clear promise, reliance, and inequity. But again, we come to the crux of the matter. In our law, Section A2, for example, has made certain changes, that the promise waive obligation is binding without consideration. So the rule in the penal case has been abolished. And since the rule in the penal case has been abolished, promissory estoppel, for example, one will argue, is even not important, because promissory estoppel, when properly understood, was a way of overcoming the problem associated with the rule in the Penal case. And if we read the full judgment of Hill and Metropolitan Railways, and then the full judgment of Denning in the Coombe and Combe, High Trees case, and so on, you notice that promissory estoppel was a solution to some of the problems associated with the rule in the Penal case. But here is the case, section A2 has effectively abolished the rule in the Penal case, meaning that if someone has promised to waive a contractual right, that promise is binding, regardless of the fact that there's no consideration. So therefore, that which was supposed to be like a solution is rendered redundant because the problem has actually been what? Abolished. Again, if we look at the section 9, the promise of performance is a valid consideration even if it's already legally obliged. So the problem in Silk and Marrick is not really a problem because of section 9. The problem in the the case of Collins and Godfrey is not a problem because of section 9. So you notice that consideration has significantly been actually shaped. And of course, our own section 26 has created estoppel by conduct or by statement, meaning that it's not necessary for you to even look for all the requirements for application of promissory estoppel. That there should be clear promise, there should be reliance, there should be this, there should be that, as under the high trace or the promissory estoppel in equity. But section 26 just make it quite straight that if by your statement or your conduct you've actually created a certain impression, then you are bound by it, as it were. Well, so after this exposition, you need to do some evaluation or assessment. So we could say that our law reduces reliance on the common law consideration, meaning that the common law doctrine of consideration has largely be rendered redundant or unnecessary, as we see from section A2, which abolishes the what do you call the rule in the Penal case of promise on waivers. Section 9, which abolishes like the rule in Silk and Marrick, the rule in the Collins and Godfrey, and also even section 8, subsection 1, which abolishes, if you like, the rule when it comes to open office. Now, section 8.1 will say that a promise to keep an offer open is binding, regardless of the fact that no consideration has been provided. So, promissory estoppel remains relevant for temporary variations, but at 25 provide a stronger contractual protection. And for that matter, the doctrine persists, but it is less central in Ghana than in England. So that is what we should note. Yes, it is there, but it's not really crucially important as under English law now. Okay, then I have two more questions to discuss, but okay, it's very short. So I need to go and do some other things. Okay, Kwame, a businessman, urgently requested Amma, a consultant, to negotiate with the Environmental Protection Agency on his behalf. Amma successfully secured the necessary approvals, after which Kwame promised to pay her 10,000 cedis. He later refused, claiming past consideration is no consideration, advised Amma. I'm sure this is pretty straightforward and everybody here can answer it. So somebody should answer it for us. Quick, please. This is the easiest question so far. And I hope you go to exams and you get an easiest question like that. Yes, Tijani.
Thank you, my Lord. Yeah, as to whether or not the promise made by Amma, that is Kwame urgently requested Amma, whether the promise made by Amma promise made to Amma will be binding. That is the past consideration will suffice as a good consideration. So first of all, under the decision of Hammer versus Sidway, the court emphasized that if there has been a specific request for which reason an act was being performed and it has actually resulted to an injury or a detriment, then of course there will be to suffice as a good consideration. So first of all, there has to be a specific request for the past consideration to be done, for which reason there was a reliance on that. And it has actually caused a detriment, which of course the law wouldn't abandon such promise, and it will be unfair if the court actually refuses to enforce such promise.
Okay. So if I understand you, you are saying that he's entitled to enforce a promise?
Yes, please.
Okay. Good. So the issues are very straightforward. First, is Ahmed's act of negotiating with the Environmental Protection Agency, is it the past consideration? Two, does it fall within the exception to the past consideration rule? So we know, as he's told us, like the principle, that the rule is that consideration must not be passed. A promise made after an act has already been performed is generally unenforceable because the past. That's the general rule. Roscoe and Thomas, but we have exception where a request has been made with the implied promise of payment, or there was a prior request, meaning that if that was done at the promisor's request and it was understood expressly or impliedly that payment will be made, then a subsequent promise to pay is enforceable, as we saw in the case of a Lampley against Brightweight. And then the Ray-Cassie kittens, and we have also noted that we have a statutory exceptions as we discussed not too long ago. So let's keep that in mind. And for that matter, we can simply say that Kwame specifically requested Amma service. So both parties will reasonably assume payment, and Amma can enforce payment as our friend Tijani actually indicated not long ago. We have one more questions. So just look at it. I mean, it's taken care of by some of the things that we've discussed already. So we're not going to discuss that, and we draw the curtain down here. I'll come your way again in the course of the day when I get the opportunity. Okay. Right. Thank you very much. So let's pray. We start with God. Gracious Lord, we are grateful for the time spent in learning together. May the lessons gained today remain in our hearts and minds. Strengthen us for the work ahead. Calm our anxieties. Guide us, recall with accuracy what we have studied. and help us to know every question which will come our way on the day of exams. May all our efforts bear fruit to your glory and the service of justice and humanity. Amen.
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 Mm.
Amen.
Right, thank you.